This is Kip from Malik and Malik. Usually, you're familiar with me talking about BWC, and I usually don't talk about personal injury cases because generally that's not what I do. But that's the other part of our the Malik and Malik practice. They do all the PI stuff, the dog bites, the slip and falls, the wrongful deaths, the etc. And that's why I have my dad doing those videos. But what ended up happening is I'm looking at these Supreme Court decisions and these various decisions on the 10th District's docket website, and I'm just seeing, hey, is there something interesting that you guys might want to listen to? So I ran across this slip and fall case, and it's a 10th District 10th District appeal case, but it's not what when I'm talking about 10th District cases, I'm talking about like mandamus cases, i.e. appeals of industrial commission orders to the 10th District Court of Appeals. This is a personal injury case involving a slip and fall that the summary judgment motion was granted on behalf of the defendant, and it was granted, and then the plaintiff filed an appeal to the 10th District, and it happened in Franklin County. So typically, if you file your appeal to the district that the county you're in, so if you're in this county, you'd file in that district. If you're in this county, you file in this district court of appeals. So it happens to be that Franklin County happens to be in the 10th District. So you're asking, so why do all the workers' comp mandamuses, why am I always talking about the 10th District? Don't people get injured in other counties, which would be in other districts in Ohio? And the answer is yeah, but 10th District has the sole, they're the ones who hear the mandamuses. So if you get injured in Cleveland and you're filing a mandamus to some order that was heard in the Industrial Commission up in Cleveland, it would be argued in the 10th District here in Franklin County. So, but this is a Franklin County Court of Common Pleas personal injury case, and so they file it to the district they're in, which is the 10th District. So anyways, so that's some background. I don't know if you folks are familiar with what summary judgment means. So when you file a motion of summary judgment, basically that when you have these personal injury cases, typically what the personal injury plaintiff's attorney is trying to do is survive summary judgment. And by summary judgment, basically there's 3 points, and I'll explain it because I'm giving you kind of word salad, and it kind of bears explaining. I mean, when I was in law school, I had to think about what this stuff meant. But anyways, for a motion summary judgment to be granted, there has to be an absence of a genuine issue of material fact. The moving party, i.e. the party who filed the motion of summary judgment, is entitled to judgment as a matter of law, and construing the evidence most strongly in favor of the non-moving party, reasonable minds could only find in favor of the moving party. So what that means is reasonable minds being like a reasonable jury. So your reasonable juror who is kind of the perfect reasonable average jury, if they were presented with this evidence that the moving party, i.e. the person submitting the motion and summary judgment, if they couldn't come to any other conclusion but what that person wrote in their MSJ, then it should be granted. So for example, like if I'm just trying to think of a simple example. If I had, like, for instance, the trial was about whether or not this was a blue, whether this is blue. So it looks blue to me, and I don't know, you might say it's teal, and the argument might be, well, I don't think it's blue, I think it's actually green. The other party is green. So one person says it's blue, and the plaintiff is saying, hey, this is green, I have a green notepad. So if I submit this, if I'm the moving party who says it's blue, I would say, well, reasonable minds would agree that this is blue. We've tested this with a hue, an RGB thing or whatever, and scientifically it's blue. When you look at it, it looks blue. So nobody else is going to confuse this for the color like green, or if I'm saying it's the other party saying it's red. There's no dispute whatsoever about what that color is. Versus so in that case, summary judgment would be granted because there's an action. There's no. If it were to go to trial, the jurors, the reasonable jurors would be like, no, dude, that's totally blue, and there's no other way that that could ever be considered red, or there's no argument about that being red or whatever other color. And then, so another example might be, I have a glass of, I don't know, let's say a glass of lukewarm water, for example, and it may be hot. Somebody might think it's hot. So the issue is, I'm saying it's hot, and you're saying it's cold, and depending on how you look at it, if this, we do discovery and we touch the water and it's like, I think it's hot, but this other person says it's cold, and we have experts in the temperature of water, and they're like, it might be cold, it might be hot. So if I submit a summary judgment and say, my summary judgment was, hey, it's hot, and you're saying it's cold, there would be a genuine issue of material fact regarding whether it's hot or cold. So in that instance, summary judgment wouldn't be granted. So it would go forward to trial, and then we would present our arguments and our evidence, or rather we'd present our evidence to the jury, and the jury would be like, I'm not sure, and they would, you'd have, if it's a PI case, you'd have, 8 jurors, and then they would consider the situation, and then they would come to their conclusion. So that's that's a motion summary judgment. So what ends up happening, and in the realm of workers' comp cases, where you'll see summary judgment is like with, like, for example, when you're trying to say to get an additional condition of substantial aggravation of a pre-existing condition, the defendant, employer's attorney might submit a motion summary judgment stating that there's insufficient evidence to support, there's no objective evidence to support that there's a substantial aggravation, and then we'd have to write something and provide backing evidence, i.e. our doctor's testimony, expert medical testimony, saying, hey, this doctor says this case law says this can be construed objective evidence, so throw their summary judgment out, let us go to trial, let the juror decide whether there's substantial aggravation of pre-existing disc herniation at L5S1, for example. So that's how we encounter it with workers' comp, kind of those kind of situations. It's really not workers' comp. It's most instances, if you're trying to get a conditional out or something, it's really, I think some employers will file them, but I think it's more of the employer's attorney trying to get billable hours. I don't know. Hey, maybe that's overly cynical, but that's kind of my take on that. Sometimes you'll see that in factual disputes, like independent contractor versus employer situations, or going and coming type situations. But nevertheless, so this is a PI case. In PI case, a lot of times the PI attorney is trying to survive summary judgment in order to then get to the point where they get settled. Because sometimes the defense will offer, like a de minimis amount of money because they think it's going to be thrown out on summary judgment, and then other times, it's once you win your summary, once you pass this, like you've defeated their summary judgment, then you got more leverage, because it's like, well, defense, I've got my expert, I've got my evidence, I've defeated summary judgment, we're going to go to trial. When we go to trial, we're going to be asking for an X number of, let's say hundreds of thousands or millions of dollars, and aren't you scared, and these sorts of things. So, pay up, kind of, I guess, is the idea. So in this case, it's called Meredith versus Arc Industries, and you could look it up on the Franklin County Court of Pleas site by inputting in 24AP-117. I'll put that in the notes. And essentially what ended up happening was there's this individual named Meredith, I think it's Mr. Meredith, and he was going to, he worked for UPS. So this is a workers' comp issue, but he would have a workers' comp claim as also because he was working, he got injured. But that's not what this case is about. So he's going to the RIffe Center in downtown Columbus, and he's going to the 23rd floor he's UPS, he's delivering packages or mail or whatever. And as he's backing out of the office suite of the 23rd floor in the RIffe Center, so there's between the threshold, there's like getting out of the office suite, there's carpet, and then there's like this tile floor, and then you have your elevator. And so as he's walking from the threshold between the carpet and the tile, he slips on the tile, and he essentially does a splits, and he suffers a pretty unpleasant injury where he ruptured his hamstring. So that sounds not pleasant at all. So and so you're thinking, okay, this is a slip and fall. Usually in slip and falls, and I think my father, Ed Malik, he did some videos about slip and falls and premises liability, and there's various duties that you owe, like licensees, invitees, and depending on who you are, the person who owns the premises is responsible, and they have a duty of care depending on who that person is, the classification of the person. So you would think, okay, slip and fall, we got to do that whole analysis, but that's not what's going on here. So the twist is there was water on the carpet, and he's not suing the RIffe Center. Instead, he's suing Arc Industries, and somehow he got word, I think, from the security guards at the RIffe Center that Arc Industries is the entity or operation or business that cleans the RIffe Center. So he's suing Arc Industries because they owed him a duty of care, and what they owed him a duty of care of is not being negligent about spilling water, because the allegation is there's water on the carpet, and he got water on his shoes, and that water, when he's going on the tileway, he slipped, and that was the proximate cause of his hamstring injury. So he's going to sue Arc Industries, and so it's not premise liability, he's suing Arc Industries, and so he has to prove a causal relationship between the wet carpet and his injury. And so what the employer does, and this is before it goes to trial, you have to file these MSJs, these motion summary judgments, by these, it's called dispositive motion dates. And Franklin County, curiously, they'll set the dispositive date before the discovery cutoff date. And so discovery is when you file a lawsuit, that's when you get to depose witnesses and various parties to this case, and you'll give out subpoenas, and you'll request information in the form of interrogatories. So these will be questions to the defendants, the defendant, and they have to answer these interrogatories. Likewise, the defendant will give you, your plaintiff, interrogatories, and your plaintiff will have to answer these questions that are in the interrogatories, and so you do all this discovery, you do these depots and whatnot, and then after that, you kind of have all the information that you need, and then before the dispositive motion, dispositive meaning like can decide the case. I don't think it's not really part of the word, but I almost want to think dispose, like disposal, like a garbage disposal, because it's like dispositive disposal. If your case is MSJ'd out, then it's done. You're done. Your case is done. So here in this instance, the defendant for Arc Industries, they're filed in MSJ, and their position is, there's no issue of material fact regarding whether or not the carpet was wet, or I guess more importantly, whether or not Arc Industries was that's actually the issue, is whether Arc Industries is the entity that made that carpet wet. Because if they made the carpet wet, then they're the proximate cause of his injuries. So, and before you ask, I guess there was no dispute that the carpet was wet. So that's undisputed that the carpet was wet. I guess there was enough witnesses and They must have stipulated to that or submitted that, yes, it was wet. We agree it was wet. There's no issue as to that. So the dispute comes to, again, did ARC Industries. So they wrote their MSJ, and then the trial court said, oh yeah, we agree with the defendant. Get this out of here. We grant the MSJ. And so the plaintiff, Mr. Meredith, and his attorneys, they filed appeal to the 10th District. And the appeal to the 10th District, they found, well, spoiler alert, they agreed that they actually disagree with the trial court, that there was a dispute of material fact, and they bounced it back to the trial court. So he could have Mr. Meredith can have his day in court. So he might lose the jury trial, but at least he gets the opportunity to do his jury trial. So why did they bounce it back? So they bounced it back for the following reason, because there was unrefuted evidence that the carpet had been wet less than 24 hours before Mr. Meredith's slip and fall. So again, there's no dispute about that. The weather on the date of the injury was dry, and I think it was like May 6th or 8th. And so they were able to look at the weather data, and they're like, it didn't rain that day, so it couldn't have been from people tracking water into the carpet on their shoes from outside. And then they through the process of discovery, they determined there were no leaks or other sources of water leaking on the 23rd floor that could be a source of the water on the carpet. But they also discovered in the course of discovery that ARC Industries employees use those water buckets with wheels. So if you ever, you've seen this. They put the mop in the bucket and then they push it. So they use those, and then there's the possibility that those could be overfilled, and then the water could fall out of those buckets onto the carpet. And then ARC Industries was responsible for mopping the bathrooms and tile floors on the 23rd floor of the RIffe Center. So for the 10th District folks, this was enough for them to say, you know what? There is a dispute here. So if there's any kind of factual dispute, if you can't say, like, without a doubt that, there's no way that this is red, it is blue, then you've gotta that summary judgment motion shouldn't have been granted. And that's what the 10th District said. They're like, there is a dispute here. There is a dispute. And since there is a factual dispute, reasonable minds could come up with different positions. Some jurors might say, well, I think maybe it was wet, and because we didn't have these other bits of information, the only other conclusion we could come up with is that it came from ARC Industries. Another juror might say, well, I think the plaintiff didn't really convince me that ARC Industries was a sort of source of the water on the carpet, for this or that reason. But the point is there's a dispute, and reasonable minds could come to different conclusions. And if there's a dispute about a factual issue, and the summary judgment is centered on that factual dispute, then you shouldn't grant the summary judgment motion. It should go before the jurors, and then in a trial, and then the jurors should decide based upon the evidence presented and the arguments presented and the law that applies. They should be the ones who decide, not the judge looking at the summary judgment motion. So that's what. And so the 10th District found that there was a genuine issue of material fact as to whether ARC Industries' mopping of the tile floor the day before led to the accumulation of water on the carpet, and then therefore the 10th District found the trial court erred in granting ARC Industries' motion for summary judgment. So they bounced it back. I don't know what ultimately happened. I don't know if the reality is this Mr. Meredith probably settled his case, and it's probably ARC Industries offered him some kind of amount that was sufficient for him and that he was happy with, and that and otherwise he would have gone on a jury trial. Here's the thing, with these jury trials, there's a potential you could win a bunch of money, but there's a potential you could win nothing. So you got to kind of balance that, whether you accept the settlement that's offered or you go forward with the trial. And with the PI cases, because there's bigger numbers involved, the stakes are way, 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 way higher. With workers' comp claims, I mean, the stakes can be really pretty tremendous depending on, hey, if somebody doesn't have any means of getting, they have a bad injury, and it's one of these kind of injuries that, like if you fall off a roof and your arm breaks, you're gonna go to the yard. They're gonna treat you, right? They're gonna fix you up. But if you're lifting a box and disc herniates, the hospital is not gonna necessarily. They're not gonna do, unless it's like an acute herniated disc where you're like losing bowel function. They're not gonna do surgery on you. And likewise, an orthopedic surgeon is not gonna just out of the charity of their heart do a surgery. So if there's some situations where people don't have health insurance, or the means to get health insurance for whatever reason, and so their only means to get something medically addressed is to prevail at a workers' comp trial. Other times you have to, maybe it's worth taking the settlement, and you have to kind of weigh the various facts and these sorts of things, whether you go forward with trial. So that's kind of the thing. But this is a slip and fall case, but it's not your typical premises liability. It's more centered about the summary judgment issue, and it's addressing versus the premises liability. They're suing something for doing something, and it just happens to be in a building. So that is the Meredith versus Arc Industries. I'll put the case site in the notes, and I'm usually at the end of these things advising people talk to a workers' comp attorney, and I'm going to continue to advise you always consult with a workers' comp attorney. But on the other side, if you have a personal injury case, particularly with these car accidents and things, it's to your benefit to consult with a personal injury attorney as well, because there might be, and also do not wait. The worst thing you could do is sit on an injury. If you're going to file a personal injury case, or you think you might have a personal injury case, you really need to get a PI attorney involved as soon as possible, because the last thing that a PI attorney wants to do is get involved in your case like a week before the statute of limitations runs, because they could potentially be opening themselves up to massive legal malpractice, and so they may be very, very hesitant to get involved with your case, because the reality is a lot of times folks, particularly if they wait some time, they'll be like, well, I was injured, I had my personal injury case, my slip and fall, my car accident, my dog bite, my whatever, I think it was this, and it's like, ooh, that's really scary. And it's almost like when there's uncertainty about the date of injury, that's dangerous. And the longer you get out from that, you just got to be really careful. And the PI attorneys, they may be very hesitant to get involved, and they might not get involved for that reason. Our firm would be we're very, very, very intense about date of injuries, and frankly every PI attorney is, because again, if they miss a statute, legal malpractice, and that's going to cost us, so we don't want to do that. And then you're not going to want that either, because you're not going to be able to pursue your case. You're going to be stuck with this legal malpractice, and legal malpractice attorney might not be interested in your case either. So if you think at all you're gonna have a case, or you have questions, please call a personal injury attorney. There's 1,000 personal injury attorneys that advertise on Google, so just find one. Ask your friends, neighbors, coworkers, whomever. Who do you guys like? Who have you used in the past? I would be a little bit hesitant about always going to the PI attorney who advertises the most or who has the most reviews. In fact, it's paradoxically the best, and I don't really think there's a big dispute about this, but one of the best, he's arguably the best personal injury attorney who handles the big PI cases in town. If you search for this guy, he actually, I think he only has like 7 or 8 reviews, and like one of them is like really negative. I think he has like 3 stars, but this attorney, and if you talk to the attorneys, so here's the other thing. Sometimes when cases are so massive and complicated, the reality is sometimes PI firms will get another attorney involved. So this guy is like the lawyer's lawyer for PI guys, and he's. But paradoxically, if you search for him on Google, his website is super old. He has only 6 or 7 reviews, and half of them are, I don't know, they must be really, I don't really understand why these folks are disgruntled with this particular attorney, because this guy literally, you could search for it, he'll never collect on it, but he got like an $800 million judgment on one of these crazy cases that he was involved, where this child, I think, died in a crib or something because of the bad construction. But you could search for that. I'll let you search on Google. You find his name. But yeah, but I would call around. I would not necessarily go to the person who advertises the loudest, on TV and these things, because it doesn't always correlate. That doesn't always mean you're going to get the best attorney. So you could go with those persons, but I would cross-check that attorney who you're going to go to run it by somebody and say, hey, what do you guys think about this guy? Nevertheless, do get an attorney involved, and absolutely with a workers' comp claim, as always, consult with a workers' comp attorney for a work injury. But please stay safe, and I appreciate you muscling through this video. Thank you. It's been Kip from Alec and Malik. Bye.